Okay, good evening, everyone. It is 7 o'clock and we're about to begin our presentation. Welcome to National Coalition of 100 Black Women Dallas Metropolitan Chapter Life Planning Session. My name is Lisa McGee. I am the chair of the Economic Empowerment Committee. In tonight's session, we'll be learning the difference between a trust and a will and the importance of the power of attorney. I will now present to you our first VP, Madam First VP Keisha Dillard.
Good evening, everyone. It's an honor to welcome you all on behalf of the National Coalition of 100 Black Women Incorporated Dallas Metropolitan Chapter. As the first Vice President of Programs, I am thrilled to have each of you here this evening, as we continue our mission to uplift and empower Black women and girls in our community. At NCBW, our mission is to advocate on behalf of Black women and girls by promoting leadership development and gender equity in the areas of health, education, and economic empowerment. We are committed to equipping and empowering our communities to overcome systematic challenges and build a future of success and prosperity. Our vision is to create a world where Black women and girls live free of socioeconomic inequity. We strive to break barriers, close gaps, and open doors to opportunities that will allow our sisters to thrive in all aspects of life. The impact of NCBW extends far beyond tonight's event. Nationally, our organizations have been a driving force in shaping policy, fostering leadership, and ensuring that Black women's voices are heard in critical conversations. Locally, right here in the Dallas metropolitan area, we have been actively working to create mentor opportunities, scholarship programs, health initiatives, and economic empowerment workshops, all designed to provide the resources and support our community needs. So tonight's program is just another step in that journey. Through our collective efforts, we are not just discussing change, we are making it happen. I encourage each of you to engage, to learn, and to take action as we continue to make a lasting impact. So thank you for being here and for your unwavering support for our mission. We look forward to an inspiring and impactful program. Thank you.
Lisa, you're muted.
Oh, my apologies. Now, Co-Sister Tingley will introduce our presenter.
And then I was muted. There we go. Well, oh my goodness, I am so excited to introduce to some Mr. Saluto Uba Esquire. Saluto is the founder and managing attorney for the Uba Law Group. He is passionate about equipping dreamers to become entrepreneurs and equipping entrepreneurs to become CEOs. With a practice focused on helping people protect their business and family legacy, Saluto uses his expertise to serve companies at every stage of success. Saluto has spent the bulk of his legal career providing counsel to numerous companies and has recovered and defended millions of dollars worth of funds and assets for clients. Saluto is also a recent alumni of the Goldman Sachs 10,000 Small Business Program. We are partners in that. And his favorite quote is, "Entrepreneurship has completely transformed my life and has given me the opportunity to leave a lasting legacy to the generations after me. This is why I'm so committed to working with everyday people so they can launch forward into the next level of transformation for their business and legacy." With that, I give you Mr. Saluto Uba Esquire.
Now I gotta make sure that I unmute. How are we doing, everybody? All righty, so what I'm going to do right now is share my presentation, share my screen, so y'all can see my presentation. It's saying I don't have sharing privileges at the moment. So while we're working on that, I'll just go ahead and do a little bit of my intro. Now, I've been told I have limited time, and the first thing that they did wrong was bring an attorney on here and tell me that I can only talk for a little bit of time. But we're gonna make it work, y'all. Okay, perfect. Can everybody see my screen right now? Okay, wonderful. Let me put presentation mode. Bam. All righty. So I got about 30 minutes. Then we're gonna hit some Q&A time. So I gotta give you guys the meat. So good evening, ladies. I want to thank the distinguished chairs and leadership of this organization, as well as Lisa and Shalina for being so integral to having me come and really present this to you. This is on my heart. I love working with families. I love working, particularly in our community, to help build our legacy and to just to really build our transitional wealth as well. People talk about generational wealth, but transitional wealth is a big part of that. So for the next half hour, I want to share what no one else has told you guys about estate planning. And really the best way to learn is to focus in. I want everyone to turn off their phones if possible, get off social media, and really focus on this being time for yourselves. However, because I came here, I knew I had to bring you guys some bonuses. So I have a few additional things that I would love to provide as just a thank you for your time this evening. So the first one is a chance to win a $50 Amazon gift card. Everybody loves Amazon gift cards, and I am no different. So if you guys will scan the QR code on your screen right now, I've got a simple survey that we like to give to folks that has additional information for how you can focus on estate planning and how it can serve your needs. So I'm going to leave this on the screen for about another 30 seconds as I talk about my background and right before we get in. So anybody who has a chance, please take this opportunity, fill out the survey. Survey takes about 30 seconds or so. And then one of the participants will win an opportunity or will win an Amazon gift card. Everybody who applies will get an opportunity for the gift card. One participant will win that $50 Amazon gift card. And that is just one of my tokens of appreciation. Say thank you for taking time out this evening and being here with me tonight, with us tonight. So I'm gonna give it about 5 more seconds, and then y'all can't say I didn't give everybody a fair chance. 3, 2, 1. Okay, we're moving onward and forward. Now, here's the question I love to ask everybody. Tell me, do you have an estate plan? And I'm a very interactive person. As y'all can tell, I get energized by this stuff. So I would appreciate some interaction as well. So y'all can go ahead and throw it in the chat. If the answer is yes, say yes. If the answer is no, say no. If the answer is not yet, say not yet. But just y'all go ahead and throw it in the chat. Do you currently have an estate plan? I'm gonna give us a little bit of time to think about that while I sip some coffee. Let's see what we got. Okay, we got a no. We got some additional answers. I'm gonna give us about 10 more seconds. Do you currently have an estate plan? Let me know. 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 All righty. So I'm gonna come back to this. Y'all think about it. Do you have an estate plan? Even if you just raise your hand, put your hand down in your mind, think about it. But here are some of the biggest doubts that people have when it comes to estate planning. Number one, a lot of times people can be really superstitious with this. They think that if you plan for your death, it'll somehow speed up the Grim Reaper coming to you. Some people are afraid that estate planning will take too much time and they just can't fit it into their busy schedules. Some people think that they're not old enough, they're not wealthy enough. Some people think that, oh, I don't have kids, I don't have a house, I don't have this, I don't have that. These are some reasonable doubts that people have that can slow down the process. But the good news is that I've never had a client pass away after signing their documents. So we don't have to fear the Grim Reaper. We don't have to feel something happening when we create an estate plan. And the real reality of the situation is that we owe it to our loved ones to make sure that they're protected. So you'll hear me say many times that estate planning is not primarily about us. It's about protecting the ones that we love and making a plan for them. And then lastly, the benefits of estate planning, they are not tied to age, it's not tied to wealth parental status, marital status, estate planning is for everyone. And so I really want to make sure that we can drive that message home. So here's what we're going to learn today in our succinct and focused time together. We're going to talk about how to name guardians for your children if you have minor children. We're going to talk about how to avoid probate court, which is what we want to do. We're going to talk about your estate planning options. We're going to break down the difference between a will and a trust. And then we're going to talk about how to protect children's inheritance and also how to make sure that you can protect yourself in the event of incapacity. But once again, my name is Saluto Uba. I have the distinguished honor of speaking with you guys tonight. And before I really get into any type of educational material, I always want people just to know a little bit about me. So this is my wife right here. That beautiful woman right there is my lovely wife, Dr. Lola Uba. And those two kids are Micah and Sophia. Micah just turned 7 in December, and Sophia is 4.5, and she will let you know about it. And so at the Uba Law Group, we are a law firm that's focused on helping people protect their business and family legacy. So we do business formation, we do wills and trusts, we do trademarks and copyrights, we help people with maintenance of their business and strategy, and we also have the privilege of doing speaking events and engagements just like this. Additionally, we love to educate. As you guys will soon see, I love to talk and just to teach people about these things. We have a YouTube page. I tell people, if you have a question about business or estate planning, if you type that question in and you type Uba Law Group, I probably have a video on it. And that's just additional ways that we like to give back. And then lastly, we do have the distinction of being a 5-star law firm. This past December, we reached 100 5-star reviews. And I share this not to brag or boast, but we do take very seriously the relationship that we have with our clients. And we're very honored and humbled in the trust that they bring to our firm when they give us these reviews. So we always just like to share that as well. Now, getting right into it, I asked a few moments ago, do you have an estate plan? And some people said yes, some people said no. But the reality of the situation is that this is a trick question. So unless you're positive you have an estate plan, even if you said no, the truth is that you do have an estate plan. It's just that the state of Texas has written it for you. Everybody, no matter what they've done, if you have not made a plan, the state of Texas has created a plan for you. And the reality is you probably won't like Texas's plan. So when we're talking about estate planning, what we're really trying to do is we're trying to opt out of the default rules that the state of Texas has for you and make sure that your wishes for your family and your assets are followed instead of what the state thinks should happen. So this is just kind of a quick breakdown of what happens for people who don't have any plan in place. There are diagrams, little specific if-then statements, instructions, and this is kind of a simplified process, a simplified breakdown of what happens. There's breakdowns for people married with children, married with no children, not married, children, all these different things. But it can be really complicated, and the big picture is that your specific wishes and desires that you want to happen, they don't occur because it has to be some generic plan that comes from the state. Now, when we're talking about estate planning, our goals are to make sure, like I said, that your wishes are enforced. And so my favorite way of describing it is that estate planning is how I give what I have to whom I want, the way I want, when I want. If you aren't driving this process, somebody else will be driving it for you. And the default rules, the default laws of the state might have your money or your children or your assets going to people that you did not want them to go to. So we have to be very intentional and take ownership to make sure that we can actually effectuate our wishes. Now, I said before that even if you don't have a plan, the state has a plan for you. And so what I'm talking about is what we call dying intestate. So dying intestate means that you do not have any testamentary documents. You don't have a will or anything in place. You don't have a trust. So if you pass away and you don't have anything created, you have died intestate. And so when this happens, your assets are distributed according to state law, which, like I said, means that they can go to people that you don't want them to go to. If you have children and they're over the age of 18, any inheritance that they receive, they get it outright 100%. And they could be lost and divorced, it could be lost, it could be spent unwisely, any of that could happen. If you have a spouse and they remarry, your children might unintentionally or intentionally get disinherited after you pass away. All sorts of things can happen. A judge will decide who raises your minor children, and they're also in control of your money, and probate court is guaranteed. I got off the phone today with an older gentleman whose son-in-law, his daughter's husband, had passed away. Young couple, and now she's having to rebuild. And they have a lot of expenses and they need to sell their house, but they can't sell their house because they have to go through the probate court system. So these are things that happen every day. So we want to make sure that we have a plan to make sure that this doesn't happen to you. Now, question that I always like to ask is, what would happen to your children if something were to happen to you? If you don't have a plan, like I said, there's a default plan from the state of Texas, but you might not like it. And that judge will decide who gets custody of your minor children instead of you being able to steer that ship and to drive that decision. Now, really quickly, I won't kind of go into the ins and outs of it, but what happens when parents pass away as what's called a permanent guardianship proceeding? Typically, if there's another surviving parent, the child will go with that parent. But in the event that there are no surviving parents, there's a procedure that's very rigorous and involved. And the state, of course, they're trying to do what's in the best interest of the child, but they don't know your family, they don't know your situation, so their ability to assess what's in the best interest is limited. Oftentimes what we see is that in-laws will battle it out for custody and they leave the courts to sort everything out. And what you see very often is what we see here in the picture is really the kids that suffer the most. So what we want to do through and through again in everything that we do is that we want to create a plan that makes sure that your wishes are carried out and your loved ones are protected. Because that estate planning piece, like I said, is about protecting the people who matter the most to you, who you love. Now, we talked about wanting to make sure that this doesn't happen to your kids. So the solution to that is naming guardians for your children in a will. So your will can state who the kids will go to. If you want your kids to go to a couple, you can also say what happens if that couple divorces or if one person dies. You can have backups. You can make sure that there's a thorough, double-checked and triple-checked plan that will make sure that your children are protected. Now, let's talk about a lot of the major things that weigh on people's mind when it comes to estate planning. What about the money? So when we're talking about our estate, we're talking about everything that we have. We're not just talking about a bank account, but we're also talking about things like vehicles. We're talking about brokerage accounts. We're talking about life insurance proceeds. We're talking about business interests, intellectual properties, real estate, of course, your home, your 401k. All of this is wrapped up in your estate. So understanding how that's going to be dealt with and what the timeline for that is extremely important. So there's really two options that people have when it comes to creating a estate plan. Three, but we'll go over the two main options. So one of the most important things to understand is that, people try and you put a good effort to make sure that their wishes are effectuated, but oftentimes estate plans will fail because of one of these reasons. Number one, they have poorly drafted documents. So, we're living in an age where AI is really coming into its own, and you have different services like a LegalZoom or Rocket Lawyer, and many times people will try to go with some of these options hoping to just get something set up, but oftentimes these options don't have the capacity to do what you need, and the documents are poorly drafted, and now you have your wishes that won't go in force. The next thing that happens is people set up their estate plan in a way that doesn't avoid probate. And we're going to get into it in a little bit, but avoiding probate is ideal, and we want to make sure that we can execute that. The third thing that happens is that people's estate documents are not updated timely. I tell my clients all the time, I just said it yesterday, an estate plan is not a set it and forget it plan. It is an evolving document. So the favorite story that I like to use to share about this is a mentor of mine. He talked about a estate plan that he did with a couple that had been married for a long time, 30 plus years. And so the husband passed away. And so the wife comes and she brings the documents to the attorney, trying to kind of get set up with the plan. And so the attorney goes through the documents. He's like, okay, everything is looking good. Everything is looking on point here. And it's like, okay, Mary, let's talk about how your husband's assets are going to be distributed. And so the wife she's stunned. She's looking at him crazy. And he's like, what's the problem, Mary? And she says, my name isn't Mary. My name is Tiffany. So it turns out that Mary was the husband's first wife. Tiffany was his second wife. He had a first wife and they split up very early on. And then his second wife was the person that was with him for the past 30 years. However, he did not update his documents. He had an estate plan created when he first got married and did not update anything. So all of his assets went to the first wife. And it sounds like an incredible story, but this is the type of thing that happens every single day. And this is why a lot of estate plans fail, because you have to make sure that your living document is growing and evolving with you. And then lastly, we talked about it a few moments ago, without a customized estate plan, your children get their inheritance at 18 years old. And if you don't set them up well, it's not protected from divorce, it's not protected from bankruptcy or lawsuits. So we talked about there's two main options. The first option is a will, and the second option is a trust. And we're going to quickly touch base on both of them. Now, a will, it's better than nothing. However, there are a lot of flaws that come along with the will, and we're going to talk about them. But the good things is that with a will, you can nominate guardians for your children if you have minor children, and you're able to nominate beneficiaries for your assets that you own individually. So a will is used to distribute assets that you own as an individual, not joint assets. If you have a joint asset, the ownership will typically go to the other person, or you can also have an asset by contract, like a life insurance policy. So if you have a life insurance policy, you actually don't need to use a will with that. It has a beneficiary, and the beneficiary will receive it. But also with the will, you'll have an executor there to help wrap up your affairs. In the state of Texas, we call that a personal representative. So that's kind of what happens with a will. So I said I wasn't the biggest fan of wills, and the reason why is that with a will, you have to go through probate court. Oftentimes people think that getting a will, I just need to get a will and then I won't have to deal with any of the drama. My family won't have to deal with any of the drama of court, and they'll just be able to get my assets quickly and boom, 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 and it'll be done. But that is actually incorrect. If you have a will, you must go through probate court to probate the will. Going through court is the only way that the will is valid and executable. So a will demand that you go through probate court. A will, additionally, it only takes care of things that happen at your death. It does not deal with incapacity. A will is also problematic if it crosses state lines, because all of the laws that the will is based on are state laws. So if you take a will from Texas and you go to Florida or New York or California, there might be complications there. Additionally, kids get their money at 18, like we talked about, and a will doesn't control the majority of your property, unfortunately. A will has a limited amount of things that it can control. And then the last thing is that a will provides direction and protection for a short period of time after you pass away, but there's no long-term planning that you can do with the will. You can't put any, if you're giving children any money, you can't put any boundaries or guardrails or protections on it. You can't really put any protections on anything. Whatever kids inherit, whatever people inherit, that's what they got. So one thing we always remind people is that where there's a will, there's a probate. And so as you guys can probably see, I'm not the biggest fan of probate court. If we can avoid it, we want to. So I won't go through all of this, but this is what happens in probate court is it's just the opportunity for anybody who has a legal right to inherit from you. They have to get a chance to inherit. And anybody who has a legal right to owe, or that's owed a debt legally, they have to be able to have a chance to receive their payment for their debt. It's a drawn out process that on average takes between 12 to 18 months. In the state of Texas, in the DFW, if you can get through probate in a year and a half, and you have a pretty substantial estate, a year and a half is pretty good amount of time for probate. But that's not what we want to happen for you or your loved ones. We want to go much faster than that. So the three biggest downsides to probate really quickly is that it's expensive. On average, probate is going to cost between 1% to 7% of your estate. So typically it's around that 4% to 5%. And so those fees come out of the estate and the court takes those fees. On top of that, probate is expensive because it's so long. We just mentioned that it's about 12 to 18 months. And throughout every month, every hearing, every inventory report, every appraisal, everything, the court has to sign off and somebody gets paid, and there's fees and there's attorney's fees, executors, all this money comes out of your estate. And then on top of that, there's the time-consuming part that we just said. And then lastly, probate is public. So if you file a will in Dallas County, Tarrant County, Collin County, Johnson County, wherever, Denton County, if you file a will, you can go to whatever courthouse.com right now, and you can look up people who filed the will on Monday. All that information is public. So whatever is going to your children, to your family, all of that is public data, and anybody can look that up. Now, if you have minor children who are inheriting things, this can become problematic because anybody can look and they can see the assets that your children have, and it can become a very predatory situation. So we want to avoid that as much as possible. Once again, I'm not a big fan of probate because it's just burning money that wouldn't necessarily have to be burned. Okay, now I don't want to seem like, like I'm just hating on wills, because they do have a place and they do have a context in which they're appropriate. But typically, we'll look at a will if you have a minimal estate, minimal assets in the estate, or if your desire is to not avoid probate, but just to make sure that we have guardians and different things like that laid out for children. So that is typically when a will-based plan will be appropriate. Now, y'all see me kind of throw shade at a will. So if a will isn't the answer, what is the answer? That would be a trust, specifically a revocable living trust. There are different types of trusts, but when it comes to estate planning, you want to look at a revocable living trust because that's going to give you options. So when it comes to a revocable living trust, this is what I call a will on steroids. Typically, the will is the most common type of estate planning document, and a lot of times people think a will does more than it actually does. So a trust, in reality, ends up doing what a lot of people assume that the will will do. So we call it a will on steroids. So with the trust, you can name beneficiaries for your assets, and on top of that, the trust is revocable. So that revocable word is one of the most powerful things about a trust. It means that you can do a lot of things. You can put assets into your trust, or you can take assets out. You can decide who one beneficiary will be, who will receive out of your trust, or you could change that beneficiary. You could even terminate the trust itself. It's revocable. You can revoke the entire thing and you can cancel the trust. While you are alive, you have full control. And then after you pass away, your trust will lock in with the rules and the instructions that you've established for it. So that is really important to remember. But just as important is the second part. A trust doesn't do anything if you don't fund your trust. What do I mean by that? So if you come to my office and we create a full estate package, and we have a trust, we have a POA, we have medical power of attorney, living will, all these documents, and we do everything for you, and then we set up your trust. If all you walk away with is the kind of the binder full of documents, and you don't actually transfer your assets into your trust, you don't have anything. The trust is only powerful if it owns your assets. So when you establish a trust, what you have to do is what we call funding a trust. So right now, if you don't have a trust, all of your assets are owned in your individual name. After you create your trust, you will transfer ownership of your assets into your trust. So for example, like with real estate, just like when someone buys a house, the previous owners deed the property over to the new owners. You would retitle your house into the name of the trust, bank account into the name of the trust, your life insurance beneficiary designation into the name of the trust. And the reason that we do that is because everything that is owned by the trust when you die bypasses the whole probate process. So no 18 months in probate court, no public database where people can see what you have. Your children won't inherit their assets at age 18 when they're a legal adult. You can actually put in boundaries or guardrails or restrictions. You can do things like requiring that your children go to school, or you got to make sure that that they're living straight. There's no alcohol or substance abuse. You can put in protections for all of these things with the trust, and you don't go through the probate process. That's why we really talk about the revocable living trust being that will on steroids, because it allows you to do the things that you actually want to do. Yeah, and so what we've noticed over the years is that for a lot of people, this is brand new information because we don't have a lot of conversations about wills and trusts and estate planning. So I'm going to use this as a time to let you guys know I'm about to come to a close. We're about to land the plane. But if you have questions, we have a Q&A time immediately following. So please write out those questions. Be thinking about them. If you want to ask the question in person or however, Shalina, you'd like to organize this. If you have questions, this is our opportunity. Don't feel like any question that you have is silly. The only silly question is the one that you don't ask. So With that being said, another thing that we often have to contend with is just some of the mindset. Sometimes trust kind of has a connotation that, oh, it's just for rich folks, or it's, for fancy well-to-do folks, trust fund babies. But the reality of the situation is that is not the case. A trust is for almost everybody. I tell more people that they need a trust than tell people that they don't need a trust. Because the situation is that if you have assets that you want to protect and you want to make sure go on to the next generation, the trust is the best way to do that. So that leads us to the question, what is a trust anyway? A trust is not like a LLC. It's not a business entity. In essence, it's just an agreement that spells out what you want to happen for the assets that you've placed in that trust when you pass away. So here's an example that I like to use. Michael, he has $400,000 in a bank account. He wants to leave it all to his son, Dwight. But in order to inherit it, he wants his son to be at least 35 years old and to have graduated college. If Michael doesn't have a trust, he can't do this. Because remember, if he has a will, as soon as his son turns 18, he gets all of it. There's no way to put any restrictions or boundaries or guardrails in it. He has to have a trust. So really quickly, let's go over the roles that happen in a trust. There are 3 roles in every trust. There's a grantor, that's the person that puts their assets into the trust. There's a trustee, that's the person who manages all the assets. And then there's the beneficiary, that's the person who's entitled to receive the assets. So when someone is setting up a trust, they occupy all 3 positions. So this is a common question that we get. If I create a trust, do I lose control of my assets? No, when you create a trust, you are the first trustee. So pretty much from a practical level, nothing changes in your life. You run your house, you run your bank accounts, you run your business, you run whatever, just like the day before you even set up the trust. You're in control of everything. But after you pass away, your trust locks in and you've appointed someone to manage your affairs. Now, once again, I want to reiterate that your trust is just a set of documents unless you transfer your assets into the trust. That title to the assets, just like all of my real estate professionals know, that you have to have title. Title is so crucial. Your title to your assets is the magic of the trust. That is the power of the trust. So this is my favorite way to describe it. I have 2 young children in elementary school right now. So one of the ways I love to describe it is that a revocable living trust is like a kid's backpack. So it avoids probate for everything inside the backpack. That's why we talk about funding the trust so much. So right now, your backpack is empty. You don't have a trust set up. You haven't put anything into it. But what we want to do is that we want to see your backpack full. We want to see your house in your trust, your bank account in your trust, your life insurance in your trust, your business in your trust. We want your assets to be in your trust and to be protected. So the process of transferring your assets into the trust, filling that backpack, is called trust funding. So you have to have everyone's heard of the term trust fund baby, but your trust has to be funded in order for it to help you. Skip the slide there. And a real quick example is that if you have a trust, if you have a brokerage account owned by John Doe, when you create a trust, you'll just transfer it into John Doe Living Trust. And so it's really that simple. It would be retitled into the name of your trust, but you still have full control. And then lastly, when we talk about trust, it solves a lot of problems. You won't lose a huge chunk of your estate in probate court. Your assets go to your family in weeks and not years, a year plus, like with a will or having to go through probate. And it's totally private, both during your life and at death. Now, last thing we want to say, with a trust, we haven't answered the question of what happens with guardians. And I'm going to go into it in a few moments, but with every trust plan, we have what's called a pour over will. Now, a pour over will is a document that allows you to name guardians for your children. And then it also gives you protection because it states that if I forget to put something into my trust at my time of death, whatever is not in my trust automatically gets transferred into my trust. Okay, so I want y'all to understand, this is really hard for me. I had to condense everything into a 30-minute version, but we really got the heart of the situation. We gave you guys the knowledge that you need to move forward and make great decisions. And so what I want you to know is that knowledge is not enough. I've done this long enough that I understand that knowledge is not enough for you to to be successful. You need to create a plan. You need to take this knowledge, you need to apply it and do something. So in order for you to use the plan, you need to figure out what you need to do, how to make it happen, when you should get started, and what's the investment to get it done. So before we move into that, I do want to talk about DIY documents. We talked about this before. And people think that, hey, I can just find a set of documents. I saw an advertisement on Facebook. I saw something on TikTok. But the reality of the situation is that people try to do this themselves and they mess things up, like that example I gave earlier. So in order to make this really easy, our law firm, the Uber Law Group, we created a 4-step virtual estate planning process. We know people are busy, people have a lot to do, so we want to make this as quick and painless as possible. So we have a 4-step process. Our first step is to have a consultation where we talk about your situation, your goals, and how estate planning can help you. We figure out what makes the most sense, a will or a trust. And like I said, I do recommend wills sometimes. It's not always a trust, but we need to figure out your situation and what makes the most sense for you. The next thing that we do is have a design meeting. This is where we lay out your total estate plan. We said that we talk about power of attorney and haven't forgotten about that. We're about to get to it. But this is where we go through your trust, your power of attorney, your medical power of attorney, your advanced healthcare directive, your HIPAA waiver, all sorts of stuff. We go through it there. And then after that, our office creates drafts of your estate planning portfolio. And we're a little bit different. Instead of us hopping on another call and having me explain 150 pages of legal documents to you for 3 hours and putting everybody to sleep, what our law firm does is we create a document review video. We send you your draft documents and we create a review video so you can stop, pause, start, slow down, speed up. You can review your documents at your own timeline and you don't have to feel rushed. And then after that, you can give us any feedback or any changes that you want us to make. And then the last part of our process is called the signing ceremony, where we sign your documents and we actually bring somebody to you to help you sign and make it very convenient so you don't even have to leave your home if you don't want to. So that's our process. Now, the last thing I tell people is that you get what you pay for. So there's times to look for bargains and there's times to avoid bargains. You want to avoid bargains when it comes to a parachute, a fire extinguisher, brain surgery, and also estate planning. This is not necessarily where we want to be bargain hunting. Now, just to kind of give you a preview of our typical estate portfolio. And when I say estate portfolio, I'm talking about everything. We spent a lot of our time talking about revocable living trust, but here in the plan, it's more than just a trust. It's the trust number one. We talked about the pour over will, that's also included, but the power of attorney is extremely crucial. So when we say in this total estate portfolio, we want to be able to cover your death, but we also want to be able to cover when you're still alive, but you just might be incapacitated. So that's where the power of attorney and the healthcare proxy come in. A healthcare proxy is also known as a medical power of attorney. So this enables people and authorizes a person that you designated to make decisions on your behalf in the event that you're incapacitated, but not deceased. And so when we create a power of attorney, we create a springing power of attorney. And all that means is that's just a fancy legal term. That means it only comes into effect if you're incapacitated. So you have people that you trust that can make certain specific decisions that you've outlined for you, and they can do things like pay your bills. They can make sure that if there's any legal decision that has to happen, they can take care of it. They can take care of any medical decisions if you have to go under the knife because you've been in an accident or something. The people that you've trusted and you've designated will have the authority that you give them to make those decisions. Additionally, we have a HIPAA waiver as part of our portfolio. So people that you authorize can talk to doctors and can talk to medical institutions and hospitals. Item number 6 right here is something that not a lot of people know about, but it is my favorite part of our estate plan in a kind of a morbid way. This is called a living will. And what a living will is, I call it the pull the plug document. So essentially what a living will says is that if for whatever reason you're in a terminal condition or you're in an irreversible condition, this is where you can lay out that you want the hospital to keep you on life support, keep you on whatever life-sustaining treatment is available, or you'd like the hospital to keep you comfortable but allow you to pass away gently with dignity. And the reason why this is one of my favorite documents is because it's at the heart of what estate planning is. We're taking our time, we're being intentional right now when everything is calm, and we're making these decisions so that our loved ones don't have to make the decision later in a moment of crisis. And so obviously, these aren't talks that anyone wants to have, but we want to make sure that we can take care of these things now while everything is calm and make these decisions ourselves so we don't have to put that guilt or that burden on any of our loved ones. Additionally, If you have minor children, we have a nomination of guardians documents, and you might be wondering, why do we have that? You already said that we get guardians for our kids in a will. But the reason why we have this document is that this is a total estate portfolio. So a will only comes to effect if you pass away. But once again, you could be incapacitated and still alive, but not be able to take care of your children. So we have documents inside the will and outside the will that protect your children. And then, I won't go through the rest, but as part of our process, we actually provide a mobile notary that will come to you at your office at your time, at your time and your discretion, and you'll be able to sign the documents at your own timeline. The majority of our clients who sign their documents will do it at their own kitchen table, and we make it extremely convenient for them. And so the last thing that I will say is I told you I came bearing gifts. So for the National Coalition of Black Women, just because you've given me so much of your time graciously, we have a special offer for anyone who is interested in just booking a consultation to talk about it. Two more things. The consultation is 100% free to everybody who's on this call. It's a $450 consultation. I've waived the fee for everyone on this call. And if you book an appointment tonight, we don't have to do anything tonight. You just book an appointment for whenever in the future. Anyone who books an appointment for later on in the future will get a $500 discount off their package. But you would have to book that appointment tonight. And the way that you book that appointment is with this QR code right here. So I told y'all I came with the goodies, I came with the bonuses, I came with the gifts, and I really do mean it. I don't take it lightly that you guys are entrusting your estate planning information, you're trusting building of generational wealth, transitional wealth, and learning about these things with our time together. So I really want to provide as much value as possible. So I just really want to thank you, and I believe we will probably be transitioning to the Q&A
Yes.
now.
I'm so ready. They got questions for you, Saluto. Well, that
Absolutely.
information was amazing.
Thank you,
And
thank
I'm
you.
going to start with the first question. So Lisa says, to be clear, her question is, so everything you put inside of a will is public, even if you have a trust. Is that correct?
Correct. So that's a very good distinction. So a will is a document that has to be probated. So even like I just showed you in the prior slide, we have a trust package that also includes a will. If it's a will, it goes to the probate court, and probate is public. So even if you have a trust, when you create a trust, the goal is to transfer all the assets into your trust so you don't have to use the will at all. In a perfect world, the only thing that would be in a will is your guardianship designation, and nothing else would be in the will. However, real life happens. You might transfer all of your stuff into your trust right now, and then 10, 20 years later, you bought a new house, or you bought a new business, or you bought something else and you just forgot to put it into your trust. So when we create a plan, when we create an estate portfolio, we have a plan for that. It's called the pour over will. And that says anything that I forget to put into my trust, by virtue of the pour over will document, will automatically get transferred into my trust. But that pour over will document has to go through the probate court, and anything that's in the probate court is public. So our big game plan is to make sure that we transfer everything into our trust while we're alive, so nothing has to go through the probate court or through a will.
Nice. Okay. Twassana says, you mentioned that a trust must be funded with assets. Can tangible items such as collectibles or heirlooms be included as part of that funding?
Oh, absolutely. And 100% of the time, for people who do it right, they are included. So jewelry, baseball card collections, art, vehicles, those are all included. For most attorneys, they'll have what's called a personal property memorandum. So your trust will be able to transfer your personal items into the trust, and then specifically to lay out, I want the fine china to go to this person, and I want the baseball card collection to go to that person. I want the card to, you can lay out all of that. That is part of the estate package. And specifically, we want to make sure that those items are included. So yes, the answer is yes. Your personal items definitely can go into the trust. Very good question.
The next question says, what's the difference between a revocable and irrevocable trust? And when would you choose one over the other?
Absolutely. One of my favorite questions. So like I said during the presentation, there are several types of trusts. The most popular trust will be the revocable living trust, but there's also an irrevocable living trust. And so the thing about a revocable living trust is that word revocable. You can revoke it. You can change your mind. Like I said, you can put assets into your trust. You can take assets out. You can terminate the trust and just blow it up and get rid of it. That's with a revocable trust. With an irrevocable trust, you cannot terminate it. With an irrevocable trust, once you put assets into the irrevocable trust, you do not have control over those assets anymore. So with the irrevocable trust, there is a trustee that has control, and the assets transferred into that leave your ownership. Now, why would someone create an irrevocable trust? There are a couple of primary reasons that we do this, and there are a few different types. Typically, where you see an irrevocable trust the most is when people are trying to qualify for government programs or assistance like Medicaid or different things like that. Typically, as people will get older, if they're depending on some of these government programs, one of the biggest stipulations is that there is an asset cap. So you can't have more than XYZ dollar amounts in assets. And what we see oftentimes with, with grandma or granddad is that they still have their house, and their house is an asset that has appreciated over time. And now their house disqualifies them from receiving Medicare or certain government programs. So what people will do is that they will transfer the house into an irrevocable trust, and they will have a loved one or a trustee or someone that they trust be the trustee over the irrevocable trust. And so now that they can still use the house, but the house as an asset is off of their personal books, so to speak. So they're able to qualify for that. Alternatively, we also have things like special needs trust, and so this is typically used by parents with children with special needs or disabilities or whatnot. And the special needs trust similarly will be able to have whatever inheritance that child would have had that doesn't have the capacity to manage it. It can get transferred into a special needs trust, and that trust, those assets now leave the child's access. So you have a trusted person that will manage it for the child with special needs, and then it'll be out of that child's name. So these are a few different strategies that people use to make sure that they can take care of loved ones at different stages of life. Very, very good question. That's a big distinction between the two.
Okay, so this question is asking to confirm whether or not this is correct. You should not include your trust in your last will and testament.
So that's technically yes or no. I got to give you the lawyer answer. So there is something that's called a testamentary trust. So there are trusts that people try to create inside of a will. That is not the ideal way to do things. So if ideally you create a revocable living trust, it is a separate agreement, separate from your last will and testament. So your last will and testament specifically will break down how you would like items that you own individually in your personal name to be managed. And it also is a place where you can give guardianship nominations for minor children. Ideally, you don't want to create a testamentary trust because that gives you that. I don't have time to get into it, but that gives you limited flexibility for how you want your assets to be managed. The whole purpose of a trust is that you're able to have your wishes executed. I said earlier, you can give what you have to who you want, when you want, the way that you want. So with a trust, there's all sorts of different things that you can do. You can specify that if you have an inheritance for each child, they're going to get 25% at age 25, and then another 25% at age 30, then another at age 35, 40. You can put specific restrictions in. If a child is struggling in some ways, you can stop access to money. If there are other issues, with a properly formed revocable living trust, you have so much capacity to really make sure that your wishes are followed. If you create what's called a testamentary trust, or like a small trust document that you just kind of staple to the back of a will, it's very limited, and it's not what you would ideally want to do. So the answer is kind of yes and no. There are certain variations of a trust that can be attached to a will, but that's not the game plan that you want, because remember, your will still has to go through probate. And the whole purpose of a trust is to avoid probate, or one of the big purposes of a trust is to avoid probate. Because with a will, now you got to wait that whole 12, 18 months. And that's in the event that nobody is disputing it. If you have a will and family members don't agree and they start to fight it out in court, this is where you get situations where people's will is probated for 3 years plus. And while the will is probated, your assets are frozen. If your will is in probate, you don't have access to them. Your house is frozen. Your bank account is frozen. If you own a business is personal property, an LLC is personal property. That business is frozen. So you want to take yourself out of the probate court. That's why we actually talk about creating the trust in the first place. That's one of the biggest things. And then there's all sorts of other benefits like tax benefits and just all sorts of different things that we're talking about. So that is technically yes, but I would not recommend it.
Okay, this next question says, do you have to transfer your 401k in the trust if you have beneficiaries named, transfer on death for bank accounts and etc.?
Yep. Very good question. A lot of times people say, hey, I've got I got beneficiaries on my bank account, my 401k, life insurance, I got a TOD, I got all these different things. And so that is true. If you have a beneficiary designation, then some of the assets can become non-probate assets. You can get it out of probate. However, the question is, how do you want those assets to be managed, and how much control or flexibility do you want over those assets? So I'll give an example. There was a couple, a young lady who got married to a gentleman, and her father gave her had a property that she wanted her to inherit after he passed away. He was going to give it to her outright, but he decided to give it to his daughter in a trust. What happened, unfortunately, the couple broke up. It was not pretty, it was not amicable, and the husband knew that his ex-wife had just received a property, so he was going to try to get a chunk of that property, through community property laws. He thought he was going to be entitled to 50% of it. The lady's father gave it to her in a trust, and because he gave it to her in a trust, the trustee had the authority to transfer the property to her outright or just give her access to the property because the property is owned in a trust. And so this is just a minor example. If she received that property in her name, her ex-husband might have been entitled to 50% of it. But because it had the trust has the power to make sure that your wishes are actually followed. So when you have a transfer on death deed, when you have beneficiary designations, you can outright give assets to people, but you lose control. If there's a situation where you need to maneuver, you need to do anything different, you don't have the ability to do that. If there's a trust and everything is still good, your trust can just, it can distribute whatever 401k assets or whatever life insurance assets or whatever. It can still give it to the person that you want it to, but you at least have the added protection of knowing that it's going to go into a big bucket with someone that you approve of to distribute it according to your wishes, versus it just goes straight out to the other person if it's just a beneficiary designation. So there's so many different life circumstances. You can never really go through each scenario, but there are lots of different life circumstances where you want the ability to be able to make those decisions in the moment and have your trustee make those decisions so that your people, your loved ones can be protected. Very, very good question.
Okay, so I'm going to jump to one question that keeps coming up. I've seen it about a few times in the chat about real estate. So
yeah.
I'm going to pull part of one question. They're wanting to understand putting real estate in a trust. So let me just read how some of the questions came in. I'm reading only part of Jasmine's question. What do you need to do to add your home to your trust? Is that as simple as stating in the trust? But then someone else said to that, can you put a home that still has a mortgage in a trust or doesn't need to be paid off? And then in the same token of that, someone was asking, what are the risks of transferring a deed into a trust? And how do you protect against theft during the process of transferring assets?
Absolutely. These are excellent questions. Let me hit them quickly so we can get the most in our time. So yes, you can transfer your real estate into the trust. So I'm gonna address primary residences, then I'm gonna address investment properties, second homes, beach homes, XYZ. So every state in the country has a statute on the books that says that your primary residence, when you transfer it into your trust, it is 100% allowed, and there's no additional benefit that can be interfered. Homestead exemption, you don't lose it. If you have a 65 and plus and over exemption, you don't lose it. If you have certain property tax benefits and entitlements, you do not lose any benefit for transferring your personal residence into a trust. This is the law in all 50 states. So that's the first thing. There's never any downside. You're not going to lose anything for transferring your property into the trust. Now, the second question is, what if you have a mortgage on the property? Because that's the law, the bank cannot call a loan. It can't interfere with anything for you transferring the property into the trust. So you still having a mortgage is not a problem at all. The property does not have to be free and clear. The third question is, how do you transfer it into the trust? Is it as simple as just stating it in the trust? No, that is incorrect. in order to transfer your asset into the trust, you have to retitle it. So just the same way that you'd have to transfer and deed the property over to another person if you sold it, what you would do is you'd go through a title company, or if you really kind of want to do it yourself, you'd draft up a deed and you'd transfer the deed to the trust, and then you'd record that deed in the at the county recorder's office. You'd have to transfer it the same way that you would transfer it in any other circumstance. The deed itself has to be titled into the name of the trust for the trust to have ownership over it. And so I believe that was all of the questions. Shalene, help me if there's something that
Yes, yep, that was it. So one part, just one last part with that, and then we have one more question to get through before we're out of time. Does that change anything with insurance when
Nope.
you're putting it? Okay, so you just, insurance is good to go.
Yes, that's correct. Oh, so let me add, there we go. That's the caveat. All these things I said, when it comes to your personal residence, it's not going to change anything. Now, with a second property or rental property, it depends. Typically, it's not going to change anything. There are some banks that are just historic for being sticklers on that. Wells Fargo is one that has a reputation where they'll give you a hard time for transferring assets into your trust. In the same manner, when you transfer an asset into your trust with a revocable living trust, it has the same effect as you owning it personally. So when you have a revocable living trust, it doesn't have its own separate tax ID number. It doesn't have to. It doesn't have its own separate tax form. All your assets owned in your trust can be attributed to you. And likewise, another point to point out is that anything that goes to your trust can be transferred out. So oftentimes, multiple properties can be transferred into your trust, not just your primary, but your primary residence 100% does not interfere with anything. Nothing can stop that. Insurance isn't going to get changed. Taxes aren't going to be changed. Homestead exemption is not going to be changed. None of that is changed. And that is by state law in all 50 states.
Okay, so I know the answer for this one, but I'm going to let you answer it. The answer for this one, Daryl, is by setting up an appointment with Saludo. But the question says, when you are setting up your trust, how much office time does it take? And what are the main documents required?
Absolutely. So one of the things that we do at the Uber Law Group is I know that you guys are busy, so I want to take that burden off of your shoulders. Our team designs our process to make it as streamlined as possible. So if I'm really being as streamlined as I've had some clients that have met with me for a total of 3 hours over 3 months, and we've knocked out their entire estate plan. So you'll have your initial consultation, which is typically about 30 minutes. You'll have your design meeting, which is about 45 minutes to an hour. This is where we map out your total estate planning portfolio. And then we go to our office and we do all the drafting. And like I showed you a moment ago, let me kick back here in the presentation. Like I showed you a moment ago, one of the ways that we're different is that we create a document review video. This screen represents our entire process. So when we create your draft documents, we send you your documents, and we also send you a document review video that has a total breakdown of every document in your estate planning portfolio and how that document functions and how it operates. So you go through that video and you can pause, you can play, you can go at your own pace. And this way you don't have to be on the call with me for 3 hours breaking every single thing down. We have a video that we create for you that does it. And then if you're good to go at the review and you're ready to sign, we can sign. But if you have more questions, you can book another appointment so for us to knock out any questions that you might have. And then we go on to the signing ceremony. So all in all, the process typically takes between 6 to 8 weeks. Sometimes it can take longer if life happens and people can't move through that review process. But we want to move effectively, we want to move efficiently, and most importantly, we want to make this effortless, burden-free opportunity for you because life is busy and we want to make sure that you guys can get this taken care of and do it in a way that's convenient for your life.
Awesome. So as Lisa comes back up, I want to just end with this last thing. I know the answer, but I'm going to let Saludo answer this one. Are you only doing estate trust in Texas?
Very good. So I am only currently licensed in Texas to do estate plans. However, I have an expansive network. So if you have another state that you need to do it or you have a loved one, please reach out to me, shoot me an email. Hey, Saludo, I saw you on the presentation. I need a trust in Georgia. I've got attorneys there. We got attorneys in Florida, California, wherever. I'll put you in contact with who you need to be in contact with.
Awesome. Thank you. And I will turn it back over to Miss Lisa McGee.
Okay, thank you so much. On behalf of our president, Sonia Irving, our first Vice President, Keisha Dillard, and myself, Lisa McGee, Economic Empowerment Chair, and the entire committee, we sincerely thank you, Mr. Saloto, for your informative presentation and sharing all your knowledge and expertise with us. Madam First VP. Is she there?
Can you hear me?
Oh, now we can hear you now.
Okay, I'm pulling up our, I'm sharing, hold on. I think. Can you guys see that?
Yes.
Yes. Can you see? Okay. First of all, thank you so much, Mr. Uba. Thank you so much. This was fantastic, amazing information. So I encourage everybody to take advantage of that very generous discount. Thank you so much. And I do have a plan, but I now have a lot of questions. I got to go back and kind of look and think that I might need to make some changes there. So thank you so much for the great information. We thank each of you for joining us and for participating tonight. Life planning and establishing a solid financial foundation are essential for long-term security, as you heard tonight. So I saw a lot of no's out there and not yet. So this is a great question. How stable is your financial foundation? So thank you very much. I think you answered a lot of questions for us there. So we invite you to connect with us and follow us on social media on Facebook and Instagram. Just to let you know, we have a few programs coming up. So our upcoming events, on February 8th, we'll have our community breakfast. It's from 9 to 11:30. It will be at the Bill J. Priest Education Center. We're bringing our all of our community contacts and our influencers together. The theme is Your Voice Matters and It's Time to Lead. So we're going to have some people, we're going to actually talk about running for office and how you can do that. So it'll be a great day, and there will be breakfast served. And then on February 26th, we're going to do our Healthy Heart Health for Sisters webinar. That'll be February 26th at 7 o'clock. So we'd love for you. So please go out there. All of these are out there on the registration is out there. So please go to our website and register. And we look forward to seeing you again. So thank you so much for taking the time out for us tonight. Thank you so much to our speaker tonight, Mr. Uma. You were awesome. So thank you so much for that. And we look forward to seeing you at our next program. Good evening. Thank you for coming.